What happens when prosecutors lie and why they almost always get away with it. In 1963, the United States Supreme Court issued a ruling that could have changed everything about how criminal prosecution works in this country. The case was Brady versus Maryland. The ruling was simple. Prosecutors are constitutionally required to hand over any evidence that might help the defense, exculpatory evidence, evidence of innocence. What happens when prosecutors lie about what evidence they have, or simply do not turn it all over? The question has a clear legal answer and a very different practical one. The legal answer is that doing so is a violation of your constitutional rights. The practical answer is that prosecutors face consequences for this almost never. I'm Michael Quiel. I'm the CEO of the U.S. Observer, an investigative newspaper that has helped over 1,200 people fight wrongful charges since 1991. I have seen prosecutorial misconduct up close. I have lived it. And in this video, I'm going to explain exactly how the system is structured to protect the people who are supposed to be seeking justice, even when they're not. What Brady actually requires, the Brady rule is not complicated. Any evidence in the government's possession that is material to the guilt or innocence of the defendant or to the punishment they might receive must be disclosed to the defense. It does not matter whether the defense asked for it. It does not matter whether the prosecutor thinks it's important. If it could help the defense, it must be turned over. That sounds like a clean, enforceable rule, and in theory it is. In practice, the system is unclear, enough procedural room to maneuver, and enough protection for prosecutors who get it wrong, that Brady violations are among the most under-enforced rules in American criminal law. Here's why. The discovery problem, Brady material does not disclose itself. The prosecutor has the evidence. The defense does not know what the prosecutor has. And the legal obligation to turn it over depends almost entirely on the prosecutor's own judgment about what is material. If a prosecutor looks at a document that might help your defense and decides it's not material, it may never leave their file. You will not know it exists. Your attorney cannot request something that they do not know about. And if the case ends in conviction, you may never find out. This is not hypothetical. The National Registry of Exonerations has reviewed hundreds of wrongful conviction cases and found that official misconduct, including Brady violations, is a contributing factor in the majority of them. Documented, verified, real cases where prosecutors had evidence of innocence and did not turn it over. What happens when it's discovered? When a Brady violation is discovered after a conviction, the legal path forward exists, but it's narrow. The defendant typically must show not only that the evidence was withheld, but that the outcome would have likely been different if the jury had seen it. That's a high bar. Courts have reversed convictions on Brady grounds, but the number is small compared to the likely frequency of violations. And what happens to the prosecutor? Almost nothing. The Supreme Court established the doctrine of absolute prosecutorial immunity in a 1976 case called Eberler versus Pashman. Prosecutors acting in their role as advocates, meaning everything that they do in the courtroom and in the course of prosecution itself, are absolutely immune from civil lawsuits. You cannot sue a prosecutor for withholding evidence, even if it sent you to prison for a crime you did not commit. They can be subject to bar discipline. They can, in theory, be criminally charged for willful violations. In practice, bar discipline for Brady violations is rare. Criminal charges against prosecutors for misconduct are exceptionally rare. The structural protection is nearly absolute. The gag rule your attorney cannot fight around there is a piece of this that people rarely discuss, and it connects directly to why the problem is so hard to address. The American Bar Association Model Rule 3.6, which has been adopted in some form in most states, restricts attorneys from making public statements about pending cases that could have a substantial likelihood of material prejudicing the proceedings. In plain terms, your attorney, the person that you're paying to defend you, is legally gagged from publicly calling out the prosecutorial misconduct in the way that might actually create accountability. Attorneys can file motions, they can raise issues in court, but publicly naming what a prosecutor has done, distributing that information to the community, applying the kind of public pressure that might actually change behavior, that risks their bar license. I want to be precise about this. The rule exists for legitimate reasons. The legal process is supposed to be protected from outside influence. But the practical effect is that one side of a criminal case operates under strict public communication restrictions, and the other side, the prosecution, routinely communicates with the media, issues press releases, and shapes public perception without facing the same constraints. That asymmetry is not an accident, and it is not without consequences for the people sitting at the defense table. What accountability actually looks like, let me give you a concrete picture of what happens in the rare cases when prosecutorial misconduct is identified and is addressed. The most common outcome when a Brady violation is discovered post-conviction is a new trial, not an exoneration, a new trial. The defendant who may have spent years in prison based upon a conviction built on withheld evidence is given another chance to be tried and with the evidence they should have had the first time. They are not compensated. The prosecutor is not disciplined, and the case simply restarts. In cases where the bar discipline does not occur, the penalties are typically reprimand, a short suspension, or most egregious documented cases, disbarment. That last outcome is genuinely rare. Reports on wrongful convictions has repeatedly found that the official misconduct can be common in exoneration cases and that discipline is rare. A 2020 National Registry of Exonerations report found that official misconduct was a factor in more than half of exonerations that they reviewed, and that consequences for officials were uncommon. That is the accountability structure. Retry the defendant, occasionally reprimand the prosecutor, and almost never make the victim of the misconduct whole, and almost never change the behavior that produced the outcome. I lived this. In my 2013 trial, an IRS agent testified under oath that a specific box was checked on my tax forms. That testimony was a key piece of evidence used to convict me. 11 years later, in 2024 trial, I finally obtained the actual tax forms. The box was not checked. She had lied under oath. The prosecutor had used that false testimony, knowing what it was, and my attorney who cross-examined her, who had previously worked with her at the IRS, refused to ask her one direct question that would have exposed her. The 2024 jury saw the actual document, saw the truths, and voted 8-0 in my favor in 4 hours. It took 11 years to expose the lie that would have been caught in day one. And the people responsible face no consequences. The system is not broken. It is working as it was designed. The design just does not prioritize the defendant. Why is this a structural problem, not just bad actors? I want to be clear about something. The problem I'm describing is not primary because the individual prosecutors who are villains. There are prosecutors who are honest, careful, and genuinely committed to justice. The problem is structural. The system gives prosecutors enormous power, near absolute immunity from personal consequences for how they use that power, restricted visibility into what the evidence they hold, and an opposing party who is legally limited in how forcefully they can respond publicly. That combination does not require a bad person to produce a bad outcome. It simply requires a person who, under pressure to win, makes choices that the system will not punish. Mandatory minimums gave prosecutors leverage to extract pleas. Immunity protects them if they will withhold evidence. Gag rules prevent the defense attorneys from fighting back publicly. And 83% of federal defendants who go to trial are convicted, which means the machine almost always wins. Understanding this does not mean the fight is unwinnable. It means that the fight requires tools that work with the system and tools that work outside it simultaneously. Attorneys handle the inside. First Amendment protected investigative journalism handles the outside. That combination is what the U.S. Observer was built to provide, and it is what's produced in our results over 33 years. The system protects prosecutors. The First Amendment is what gives defendants a fighting chance against that protection. In the next video on this channel, I'm going to take you deeper into my own case. 15 years of fighting the Department of Justice. The tactics they used when the evidence was not on their side. How they applied pressure and how the moments where the path forward was not clear. If you've been watching this channel from the beginning, you already know that the story ends. But the middle of the story is where the lessons are. I am Michael Quiel. Subscribe if you have not. I will see you in the next one.